Hello, I'm Tom Grace from Fenwick, Elliot Grace, and this is a short discussion on the recent cost increases that have occurred in the construction industry and whether we're enabled to get variations as a result of those increases, whether we can terminate the contract. The video answers questions particularly about the MBA HB 2019 contract. First question that we look at is, can I get a variation for cost increases of materials and labour since I signed the contract? If I signed a contract and if I go ahead and I'm going to make a loss, can I terminate the contract? And can I agree to pay the owner money to terminate? If not, are there terms in the contract that I might use to force a termination of the contract? This video is for general information. It's not legal advice. You should get your own legal advice about your contract and your factual situation, because legal advice must always be given on the basis of the facts of the situation. And while construction contracts allow for variations, most disputes with owners arise out of variations. And if you follow the terms of the contract carefully, that'll help to minimise the risk of those disputes that do arise. So a question I get frequently is, I quoted my project 12 months ago. Now it's going to cost me 25% more than when I quoted. Can I use a variation to get an increase in the price? Generally, the answer to that question is no, but it does depend on the facts that apply, because a fixed price contract is just that, unless the contract terms themselves allow for a price increase. Under the HB 2019 contract, clause 10 talks about variations. It allows the work to change during the performance of the contract, and these changes are variations, and the builder can get extra cost and maybe extra time. If possible, clause E, subclause E says the price for the variation must be given to the owner before the work commences. Otherwise, it should be given as soon as practicable after it's known to the builder. And then the builder can claim payment for any variation in the next progress claim. So how could a cost rise cause a variation? There are some specific circumstances as set out in the contract terms where an increase in costs can be the subject of a variation issued by the builder. On each occasion, we have to look at the facts to see if one of the 6 factors that are set out in clause 15 of the HB 2019 contract has arisen. So let's look at clause 15. Clause 15 generally gives us more time to build if certain events occur. If a delay to practical completion occurs, clause 15 sets out the possible extensions to the practical completion date that are available to the builder. And there are many sub-clauses in clause 15, but 6 of them entitle the builder to not only claim an extension of time, but also to claim more money by raising a variation. I'm going to call these the 6 factors. So these 6 factors are as follows. If the work is held up by 1, the owner failing to give or delay to give instructions or directions, or 2, someone the owner has asked to do work or supply materials, plant, equipment or goods is late, or 3, the builder carries out variations or other additional works, or there's any delay or disruption or stopping of the work due to any act or omission of the owner, or 5, the delay of any local or other authority in giving approval, and finally the 6th one, which is number 13 in the clause, legal action by third parties affecting the site. So for example, the neighbour took out some sort of action to stop the work going ahead. Now if one of these 6 occurs, then the builder can raise a variation, and that variation can claim for loss and expense resulting from the delay that's been caused by one of those events. Clause B says if the cause of the delay is one or more of these events, then the builder can claim any loss and expense resulting from the delay. These are the only 6 factors that can lead to more money. That is, a delay in instructions, the owner's supplying something, there are variations that have occurred, There's an act of the owners that causes it, or an omission of the owners. The local authority, for example, the council is delayed to give approval, or the neighbours perhaps, or a third party has taken legal action. Particularly note that where the owner asks for variations to the contract that have led to a delay, that might entitle you to claim cost increases. There are several other factors in clause 15 that give you more time to reach practical completion, but those factors don't give you extra money. So if I want to claim a cost increase under one of those 6 factors in clause 15, well, first of all, be cautious. Don't overestimate the real cost caused by the delay. Have some backup for your claim. This is not about making an error in estimating and making up for that error. It must be actual cost rises, and you must raise the variation as soon as you know about the increase in cost. Remember those words, as soon as practicable. So if the build hasn't started yet, then raise the variation and ask for proof that the owner can pay. We'll talk about the reason for that later. The next question I get asked is, can I get out of the contract? The cost increases might have made the contract unprofitable, and you haven't started the build yet, so you might want to end the contract without building the project. This is called terminating the contract. The termination of a contract brings the parties' obligations under the contract to an end. But be careful, because if you terminate illegally, the owner can claim future losses from you. And you should never terminate without seeking legal advice about your situation. Illegal termination is what's called repudiation, and that can result in a substantial claim against you by the owner. I'll give you an example. Imagine you've signed a contract to build a house for $600,000, and price increases have made it unprofitable. You know you're going to lose $50,000 if you go ahead and finish it. So you say to the owner, I refuse to build it. I don't care about our contract. Well, that would be called illegal termination. That would be called repudiation. And if the owner then goes away and signs a contract with another builder to build that house for $750,000, they've lost $150,000. And they can claim that $150,000 from you. They can turn around to you and say, you told me you were going to build it for $600. You didn't build it. It's cost me $750. You have to pay the difference. And that would result in a very expensive fight with the owner if you didn't pay the $150,000, and you would probably lose. Parties can terminate their contract by agreement. They can mutually agree to terminate. So if you know you're going to lose money if you proceed with the contract, you could say to the owner, look, I'll offer to give you $10,000 so that we can agree to walk away. We'll terminate by agreement. If you like, that's what we'll do. And the owner might say, yes, I'll accept $10,000 from you to walk away. And then if that is worked out and everyone agrees to it, the contract is terminated. But be cautious about this approach. Get this in writing and make sure you get legal advice before you make the offer. And never on any terms say to the owner, I refuse to proceed, but I'll give you $10,000. Don't put it that way. It's always an offer to terminate, and it must be done by mutual agreement. How can the builder impose termination? Clause 21 of HB 2019 provides a mechanism for a builder to impose termination. It's unlikely, but let's say possibly there's been a delay in land subdivision, possibly due to price rises caused by a delay under one of the 6 factors listed in clause 15. The builder can terminate the contract if the owner doesn't give proof of ownership of the site, doesn't give proof that the owner can pay the price, and subject to B and C below, the builder can either suspend performance or terminate the contract. But note that if the default can be fixed, the builder first has to write to the owner and say, I'm going to terminate the contract if you don't fix the default. And if after 5 days the owner hasn't fixed the default, the builder can either stop work or terminate the contract. And if the builder elects to terminate the contract, the builder will get paid for all its work performed and costs incurred, including an allowance for overhead and profit, and can keep the deposit. So that's a very powerful clause, but obviously it only works if we can get through that hurdle in clause 21A. And those 2 possibilities are that they don't give you proof of ownership of the site and don't give you proof that they can pay the price. I want you to note the definition of days in HB 2019 contract. It's periods of time expressed in days, don't include Saturdays and Sundays, rostered days off, the building industry Christmas shutdown period, and public holidays in South Australia. So be cautious when you're counting that 5-day period that you have to give under Clause 21. So Clause 21 says if the owner must give you proof of ownership of the site, and they must give you proof that they can pay. So perhaps you suspect that the owner can't prove they have sufficient finance approved to cover the cost increase that you're going to raise under a variation under Clause 15. Or maybe you know that the owner can't prove they own the site. There might have been a delay in subdivision. Then what you have to do to try to get a termination under Clause 21 is to write and give them the chance to provide that proof. And they have 5 days to provide the proof, remembering the definition of days that we talked about a moment ago. And if they fail to provide the proof within 5 days, then you may be able to legally terminate. But always get legal advice before you take this step, because each situation is different. Some common questions that arise are like these. So my suppliers are saying I have to pay more to them even though I've accepted their quote, and they're saying unless I pay more, they won't deliver my timber. What can I do about that? Well, they are breaching their contract with you, and you have a right to claim damages from them. But the problem is that, say for example, they've quoted you $25,000 for the timber, and they're now saying they're not going to deliver it unless you pay $30,000. It's going to cost you a lot of money to have that fight, and it's going to take a long time to have that fight. So maybe what you should do is you should get some legal advice about it, perhaps write them a letter and say, look, I'm going to go and buy the timber from somewhere else, and if it costs me more, then I'll be claiming the difference from you, similar to what the owner might do against you if you break your contract with the owner. Another question I get asked sometimes is, if a variation has caused a 2 months delay, can I claim the cost rises that have occurred since the contract was signed 6 months ago? Well, the answer to that's no. The variation, Clause 15 variation cost increase mechanism only applies to the extent that a particular variation asked for by the owner has caused the cost increase. So you're only going to get increases that relate to that 2-month period. Remember that termination is risky. Never terminate without seeking legal advice. If you're issuing a Clause 15 variation for increased cost, there is a risk that the variation will be challenged, a high risk. The owner won't be happy about losing out on their contract, and they're probably going to go and get legal advice about whether your variation is valid. Remember that this presentation that you've been listening to is not legal advice. It's for information only, and you should seek legal advice about your particular situation.